Hello, Dr. Khan. This is my recorded presentation as requested on the Model AI Attorney, which is what I've, structured this presentation around. So it's going to be a comprehensive examination on how AI is reshaping the legal profession. We'll talk about the ethics, the framework around adoption established by the American Bar Association. We'll talk about the benefits in terms of efficiency from the practitioner standpoint, as well as the expanded access to justice um, for every citizen. And by way of background, I have been practicing patent law for 20 years, and I have also developed AI models in the practice of patent law. And so my models are being used by hundreds of patent attorneys and drafting a lot of patents. And over time, I've aggregated a lot of data and information. However, this is going to be independent of that, and it's going to be comprehensive for somebody in any legal field with any background. So let us begin. All right. All right. So the premise of why LLMs are going to be so disruptive, why generative AI is going to be so disruptive, is because law is a language profession. It's language centered. All the work involves written or verbal, some form of verbal work, whether it's ingesting intake of facts, doing the legal research and underwriting, doing the writing of the work product, presenting arguments in front of a court, consulting clients, um, and reading the opinion of a judge. All of that is language centric. And of course, larger language models are specifically optimized for language. And this is what makes law and large language models a perfect match for disruption in the way we do things for the purposes of increasing access to legal justice. And so we are a knowledge worker economy. Most of the people in the United States, maybe even around the world, are knowledge workers. We use our knowledge to output information, ingest information, and produce some sort of knowledge-based work product. And so LLMs, they, if not now, will soon outperform most humans in the processing of language at scale. In fact, GPT-4 scored in the 90th percentile on the bar exam. And, specifically where I believe generative AI and LLMs will assist is in technical subject matter areas where lawyers often don't have a lot of technical expertise. And oftentimes the cases they work on require a high level of technical expertise. And that's, outside of their competence. And so having good LLMs will help them understand the facts of their case, understand the underlying technical issues. And so, on top of which, the LLMs have cognitive advantages. They've got more memory, they can detect patterns, and they don't get tired. And so, with that, I do believe that humans will not be able to match what AI can do in the legal profession. And there's a few reasons why I believe legal work is ripe for AI disruption. The first is that it's language based, as I mentioned before, but it's also rules constrained. In other words, the practice of law is codified by law and precedent. And oftentimes, while you do want a good lawyer who help you maneuver legally, that good lawyer should not be inventing rules or inventing laws. And so you have strong guardrails in which the lawyer can perform their duties. And this means it's a different type of creativity. It's creativity within the guardrails. And I believe LLMs are going to be exceedingly good in creativity within the guardrails, within the rules, within the precedent. And by doing these things well, you're going to make legal services more affordable. And right now, for instance, in patent law, patents aren't cheap because you require legal expertise as well as technical expertise and a whole lot of training and multiple bar exams to get into the profession. And so the supply is short. And of course, the economics around that make for a more expensive process, but also patent examination is very difficult. There's a lot of back and forth, and your representative needs to not only understand the laws, but the technical nature of the invention, which can be very complicated, and they have to understand it in a way to persuade the examiners at the patent office. Generative AI is greatly assisting with that already today. And that means more people are going to get access to the legal system affordably. So let's talk about the framework. This is kind of the boring stuff. We'll get through it quick. But what are the rules that we need to make sure that we adhere to when we adopt AI into the legal practice? And I've listed the rules here: the competency rule, the client communication rule, the fees rule, confidentiality, conflict of interest, candor to the tribunal, and responsibility of the supervisory lawyers, and responsibility with regard to non-lawyer assistants. We'll cover all of those, and you'll see why these are the constitute the legal framework for adopting AI into the legal practice. So one, duty of competence. As a lawyer, you have to know what you're doing before you agree to represent a client. And in particular, the patent profession, you can't represent a client in a technical area where you don't have technical competency. And it's not enough that you know how patent laws. You have to understand the technical nature of the work involved. And so you have a duty of competency, but that duty actually extends to technological competence. In other words, it's not just about knowing the job, but it's about knowing the tools needed to perform the job efficiently. And there's almost an obligation that you do seek out the latest approved and efficient tools in doing the job, because you are expected to be a competent attorney, a competent representative. And so you have to have the latest tools of your disposal. So we do have this duty as attorneys to make sure we're always adopting the most efficient technology. You have client rule number 1.4 of the American Bar Association model rules. Client communication. You have to disclose to your client, and it has to be an informed consent. And you have to tell them what you're doing and how you're doing it. And it has to be material. Obviously, if you use a search engine and the search engine has AI built into it, you don't have to disclose to the client that you're using AI. But you do have to be transparent as to where you're inputting your client information into an AI model, and you have to get their informed consent that you're doing so. Next is my favorite, reasonable fees. You can't bill a client for training on using new tools such as AI. Believe me, there's precedent out there for this. And so attorney may bill clients for AI-assisted legal work that creates value, but they have to be transparent, and they can't bill on the time spent learning the tools itself. And this is actually what I'm finding in actual practice to be one of the most disruptive factors. And the reason this is a very disruptive factor is because lawyers are generally, let's say the ones that are 55 to 60 years old plus, they're comfortable with the amount of time they spend doing their work and what they bill their client for that work. They're happy. They found their life balance. And what they're worried in adopting these tools is all of a sudden, yes, it'll take them less time to perform the work product, which means they're not going to be able to bill as much anymore, right? It would be unethical to bill the same amount because of this rule. And as a result, they don't want to see their income shrink. So if they don't adopt AI and they already have their client base and the client base isn't pushing them to adopt AI, then there's no reason for them to adopt AI. Otherwise, they'll be like making less money because of this rule here. And so they're close to retirement and they believe they can go through the next 5 years unscathed in that sense. And it's a very ethical way about it, in some senses. And the clients aren't really all comfortable with their patent attorneys using AI anyway. So it could be a happy medium in that regard. But once AI is starting to get adoption, then clients are going to start expecting it, and they're going to start expecting their fees to drop. All right, confidentiality. Now, in addition, that the rule that requires the client to provide informed consent, um, you also have to make sure that whatever tools you're using maintain confidentiality and protections. And as we'll see with the other rules, this is actually a little more complicated than first meets the eye. AI systems have to be siloed and secured by design. And cross-client training without explicit informed consent is an ethical violation. And here's what I mean. And I think we'll touch it on the next slide as well. But you can't have your data set commingled with other data sets, for instance, opposing counsel, right? You can't be using the same AI model that's learning on your work, because then that AI model knows client A secrets, and client A, let's say, is in a lawsuit with client B, and it also knows client B secrets and strategies, right? And if you're using the same model to generate work product or assist and consult in any way, that model has access to both the data sets. So they have to be siloed in that sense. And the confidentiality is very important. And it's actually Rule 1.7 requires that lawyers do not have any conflicts of interest. And what that ultimately means is, even within your own firm, if you have proprietary data of one client that might disadvantage them when representing another client or vice versa, you have an increased obligation never to commingle that data. So AI can't train on one of your client's data for the benefit of another. And in patent law, that's very important, because when I'm writing a patent for one client, their secrets, pre-published patents, can't be used by the attorney to improve the patent of another client. And so even within the law firm, when you're using AI models, you have to take care to ensure that client data is not commingled, because it can present issues in certain circumstances. So you have to have strict technical data segmentation between matters and clients. And this is actually one of the major challenges in enabling proper infrastructure and architecture of these model implementations within the practice of law. Next, candor to the tribunal. All right, this is where all the funny cases that you might have heard have been occurring over the last few years, where lawyers submit documents to courts, and those documents contain hallucinations, made up case citations that serve as precedent, saying, Judge, you should rule this way because in a prior case, the court ruled under the same facts in my favor. Well, when you submit those type of briefs to the court, you have to make sure all the cases you cite are real cases, obviously. But with AI, these are actually hallucinations oftentimes. And it's an interesting case in Matza versus Avianca. Was a personal injury case where lawyer's client got injured on an airplane. The plaintiff's attorney submitted hallucinated case law, fake case law. And when the judge said, hey, give me proof of these cases, I can't seem to find them, the same lawyer went back to the AI model, ChatGPT, I believe, and said, hey, provide me with the actual documents for this case. And sure enough, ChatGPT provided documents for the case, which were hallucinated. And that lawyer submitted the hallucinated documents as evidence of the hallucinated cases to the same judge. The judge went crazy. So This was before, I suppose, the excuse was the lawyers didn't even know these AI models can hallucinate in the first place. So there's a rule that whatever you submit to the court, you have to certify and sign, that this has been fact checked properly. Supervisory responsibilities. Now, you can delegate to juniors. You could delegate to a paralegal. You could delegate to these people, and you have a duty to supervise them. But when they're a licensed attorney, even though they are a junior attorney, their license is invoked. So you have, let's say, a lowered burden. If they commit malpractice, it's also their license on the line, not just yours, in many ways. And so, but for AI, that's not a licensed professional. So you have an increased duty to make sure that the AI outputs comply with all the rules, including the ethics rules that we mentioned. No conflicts of interest, confidentiality, informed consent. Okay, and you can't delegate out this duty, and it requires continuous review, continuous monitoring, testing, and validation that the outputs you're producing are in accordance to the ethics rules, and that the way you're sharing your data with the AI models is also in accordance with the ethics rules. So, Rule 5.3, non-lawyer assistance. This is, in fact, a non-lawyer, and so you have to review. It's not like delegating to a junior attorney. You have to review everything by this output, right? Generated by the output. So that covers the legal framework. And so when we have AI systems out there in the practice of law, we want to make sure that it adheres to all the ethical rules, that it's got proper client isolation, and it's confidential and privacy focused first. Confidentiality and regulatory compliance, they cannot be optional features. They must be the foundational principles on which the AI models that run within a law firm or are used by a law firm, they must be the regulatory framework. So in the prior slides, I've discussed what rules are available. They're not that many, but the ethics rules are key. And law is a state-by-state practice. And what I went over are the model rules that each state is given to adopt their own version of. So every state will have a slightly different version, but these are the general model rules. All right, now let's talk about the actual disruptive opportunity in the legal practice. How are things going to change once we adopt ethical AI in the legal practice? And so, number one, I've said it over and over again, I'm excited that it's going to provide expanded access. In my profession, it means it's going to be easier to file patents. It's going to be more affordable to file patents. It might even be super cheap, close to free to file patents in the future. And right now, a lot of the disadvantages of the patent system are in the cost, in the duration of the process, and the cost of enforcing these patents as well. And so that's given patents a bad rap in engineering communities and a lot of high-tech communities, actually, where like, oh, we don't need a patent, you just need to be first to market and all of that talk. Well, it's in part because of the difficulties in the patent system. When you eliminate those difficulties, you're going to have an increased reliance on the patent system, which in a knowledge economy is pretty much, the holy grail. In a knowledge economy, your intellectual property is your commercial right. It could be your only commercialization opportunity. So when we have enhanced efficiencies, that's when the costs are going to get reduced without compromising the quality. And it's, like I said before, you always have to stick to the legal framework we discussed. Prioritize the client interest, prioritize the client data, confidentiality, segmentation. Don't commingle things. Right now, the legal spend on technology has grown 3x between 2023 and 2024. And by 2029, it's going to be projected to be at 55 billion. Right now, we're in the mid 20 billions. And so that's around the basis of about 5 million lawyers in the world. But what's going to happen over time? So there's going to be a great disruption into the role in the role of the lawyer. So some of the resilient lawyers are going to be the ones who I say, show up in a courtroom or show up in a boardroom. The ones that you really trust on advice and counsel, and the ones you need to advocate for you. And those are going to be the resilient roles. AI is going to assist them in generating work product. The transitionary roles are going to be the researchers, the underwriters, the drafters, who are doing the writing in the research, the technical work behind it. Whereas the resilient roles, the counselors and the litigators, are going to be using AI to assist them in doing the job. The researchers and the drafters and the junior associates, they're going to be used by AI to generate the work product. Imagine a factory worker used to assemble things by hand. Now they operate a machine to help the machine assemble the product. And that's what's going to happen with a lot of these transitional roles. And so we have a paradigm shift. Whereas before we saw as automating technology of automation of repeatable work, now it's not just repeatable work that's going to be automated. It's that all knowledge work is going to begin to be autonomous. So what's that mean? Yes, increased productivity. You're going to have more bandwidth per attorney, okay, which means you can decrease your headcount at your practice. You're going to be able to have a consistent work product across the board, meaning all of your team, they all define definitions of technical terms the same way, their clauses read the same way, and you begin to have a consistent brand of a product that comes out of your firm. You also have enhanced training. What I mean by that is the new lawyers that come into your firm, they're going to have, right, the old way of is you knock on an attorney's door and be like, hey, do you have any extra work for me? Can you go over a case with me? And you hope and pray they have time, right? That's how it's done, and at least before we all went remote. But now you can give a junior attorney a case, and the AI can work with them, ensuring they understand what they're doing and generate a work product that the supervising attorney can quickly sign off on. So now we're delegating training down to the attorneys. Finally, your team can do more types of work, meaning you've got greater competency with the power of LLMs that are like, almost PhDs in any subject matter. So it's going to result in faster output, lower costs, and more productivity. These are very important market dynamics. And, clients are going to start to expect you do more, you deliver it faster, and you do it for cheaper. And if you're not adopting AI, they'll take their business to somebody that does. How will this impact the economics of a law firm? Well, if you're hiring less attorneys because you can do more with your team, I think that ultimately means that the demand for new law school graduates is going to drop, and so there too will the supply drop. And so you're going to have this change in supply and demand, less demand, less supply, which means there's a stagnation of the amount of attorneys and a slow decrease over time as senior attorneys retire and fewer attorneys come and fill those roles. And because there's fewer expertise in that senior role, that means that actually the billing rate of those senior attorneys increases. Although keep in mind, they will have significantly higher throughput per professional. And so the implementation of how you do this in a law firm is what we want to talk about next. It's not about adopting GPT or Claude Anthropic or any particular model, but it's about having the right infrastructure to do so in a competitive way that helps your clients and meets the ethical obligations. So we'll talk about a little bit, specialized AI that learns about your firm's style, syntax, structure, as I said, definitions and clauses, but also about your client-specific preferences that every client might have a guideline for. It's trained on this product. It's a private process, so each law firm contains their competitive advantage. And as I'll mention a little bit later on, it learns and it becomes your model AI associate. And one day, I envision that every law firm, as today they tout their Harvard law graduates or their best competency and their wins and accomplishments amongst their lawyers, tomorrow they might tout not just that, but also their legal AI associate, their model AI attorney. So let's take a deep dive on how law firms are going to actually implement to obtain this competitive advantage, how they're going to do so while maintaining the legal framework we discussed. So public data is likely tapped out by all these models. And so that true value lies in the proprietary internal work product that's not available by these public models. And so you have at a law firm, especially one that's been around for many years, a library of knowledge, a library of practices specific to clients, specific to practice areas, specific to practice groups. These are going to become the new gold. They're not really, truly, I believe, required with how good LLMs are becoming. But there are nuances that those LLMs were not trained on because that data was never public. So that's factor number one. You have an untapped resource in that private legal data. And by securely leveraging every law firm's knowledge base, the firm can create a powerful competitive advantage that can't be easily replicated by other firms. So the AI attorney watches everyone. That AI model that you're building in your firm that you're going to start doing today, it's into your email systems, your document databases, your word processors. It's got the billing records. It's got the matter information. It's got the docket monitoring. It's got your client profiles. And it's continuously training your associates, revising the output they produce for faster supervisor approval, meaning it's got all this data. And therefore, the output that it's producing keeps getting better and better. And that therefore, your associates become more and more efficient as they work, which means the senior level partners are signing off quicker. And this is how we meet the client objective for more services, faster delivery at lower costs. The AI attorney who watches everyone. But it must be ethically segmented. So, critical danger areas are trade secrets. Law firms, especially intellectual property law firms, they have confidential business information, and you don't dare put it into a public model. They have deal terms, sensitive negotiation strategies that might not be wise to leak between clients, and they have pre-published patent data as well. These are just a few examples. And even if you have your private model, but it sees everything across clients, you still have that problem of that very same model commingling client data to produce an unfair advantage for one client over another by having used another client's trade secret data, right? So AI systems must be designed to prevent this information leakage between matters and clients. And it's not just a best practices. This is actually an ethical and legal requirement. So the multi-segmentation framework, multi-level segmentation level framework is, here's, there is no science of this. This is my study, my proposal, is you've got the user level at the very top. Like I'm the actual user. I'm the one writing the patents. I've got my rules and my preferences. Then I've got the client level, meaning who's the client I'm representing? How have they defined terms in their patent application? How do I keep consistent with that? What are their guidelines? What is their style? Then I've got the practice group, meaning what is the overall authorities and rules established by the group of attorneys who are practicing at my firm in the same practice area, perhaps even for the same clients. That's the third level. And the final level is the firm level, meaning this meets our firm standards. So you've got the firm standards, the practice group standards, the client standards, and the actual drafting attorney standards. All of these 4 items are segmentations and customizations of the output that you have to take into account when generating a work product. And this effective data segmentations, this is what requires a carefully designed architecture that separates information at all these levels while still enabling the appropriate knowledge sharing between data sets where it is ethically permitted. Of course, without this segmentation, as I mentioned before, you can get in a lot of trouble. You can create conflicts of interests, you could be in malpractice, and overall, unsegmented AI represents a serious liability, not an asset. So this is going to be a key implementation hurdle. And, we have real-world constraints in adopting these models. Law firms, they're not tech agencies. How are they going to build this out, right? Some large firms have very sophisticated tech teams, IT teams, but most don't. And it's actually not practical because how quickly LLMs evolve, generative AI evolves really quickly. These frontier AI models, they move too quickly for a law firm to be in the business of developing this on their own. And there's that technical debt, right, of having a private model and maintaining it. So how are they going to go about meeting these needs? Are they still going to have to use a public model? If so, how are they going to fit all the framework that we just discussed, the privacy, confidentiality, the ethics requirements? And so there's a big competitive disadvantage in that regard. And clients will increasingly mandate what models you can use, what models you can't use. And that may include even their own private models that you say, hey, if you want to use AI on any of our data, on any of our work, you have to plug into our AI model. So how does the firm transfer all that knowledge from one client model to another as they hop around between models to service their clients while keeping up with the advantages of AI? And so that is the big question. And my company has solved this problem in one way, and that is to have portable data. You leverage these existing models to build out your own AI workflows and your own AI prompt sequences. So what I mean is, whatever model you throw my way, I have established a way to speak to that model using my private data in a way that optimizes the output of any model to fit my needs. Thereby, I will never train any other model. I've already took in my data, studied it, built out workflows, let's call them retrieval layers and prompt sequences tailored to my practice such that whatever model I plug into, I'm going to be able to keep my competitive advantage using that model. So that's one way to structure it. And, we're patent pending on this. We're happy to share more on that in another discussion. So transportability is the power of a law firm to meet all of these needs. You move your legal intelligence across different LLM platforms. You never train any one LLM. You do your training in-house to build those workflows, the retrieval methodology, prompt sequences to speak to any LLM. And this creates a seamless way to adapt to varying client technical environments. You're never locked in with any one vendor, and you never have to compromise your data. You never have to export your data. So this is a proponent, rather, I'm a proponent of this methodology. And I believe it is going to be how we solve these problems. So, in conclusion, the transformation is inevitable. We are going to have the age of AI. All the problems that we discussed are solvable. And of course, it's going to be human AI partnership. Humans not going to be replaced, but their productivity is going to increase. So there's not going to be as much need as for so many lawyers. And I believe overall the costs of legal services will go down, and the path forward will increase access to legal justice. That is my vision, and I hope that we can achieve it in the next 2-3 years. And thank you very much for this opportunity to present this to you. I will share these slides along with the paper accompanying these slides.